Kampo ni dating Senator Bongbong Marcos nababahala po sa paglipat ng COMELEC. Ang kasama mo sa Balita Radyo Man, Silvestre Labay.
Nababahala ang kampo ni dating Senador Bongbong Marcos sa paglipat ng tanggapan ng COMELEC sa ginanap na forum sa Kapihan sa Manila Bay. Sinabi ni Atty. George Erwin Garcia na ilang beses nang pinadalhan ng notice ang COMELEC upang lisanin ang Palasyo del Gobernador dahil hanggang December 30 na lamang ngayong taon ang petsang ibinigay ng Office of the President sa COMELEC upang ilipat ang kanilang mga mahalagang dokumento. Paliwanag ni Atty. Garcia, gagamitin umano ng tanggapan ng Pangulo ang Palasyo del Gobernador. Pinangangambahan ni Atty. Garcia na sa posibleng epekto na gagawing paglipat ng mga dokumento at record, lalo na at nakalagak sa punong tanggapan ng komisyon ang mga ebidensyang patungkol sa election protest ni Vice Presidential Aspirant Bongbong Marcos. Nag-aalala naman niya ang kanyang kliyente na may masakripisyo o makaligtaang record na mahalaga sa isinusulong na election protest laban kay Vice President Leni Robredo. Kasama mo sa Maynila, Radyo Man, Silvestre Labay ng DZXL 558 Tata, RMN.
Maraming salamat Radyo Man, Silvestre Labay. DOH nakipag-ugnayan po sa WHO para mapababa ang kaso ng maternal at non-natal sepsis. Ang kasama mo sa Balita Radyo Man, Raquel Bayan.
Kasama nga nakipag-ugnayan ng Department of Health sa World Health Organization upang pababain ang kaso ng kamatayan sa mga bagong panganak na ina at bagong silang nasanggo dahil sa sepsis o yung infection sa pagbubuntis. Ayon kay Health Secretary Francisco Duque III, nagsimula na ang ginagawa nilang pag-aaral kung saan mga piling babae dito sa Pilipinas ang sumasailalim ngayon sa obserbasyon ng Health Department at tatagal yan hanggang sa December 4. Ayon sa tulihim, ang mga datos na makukuha mula dito ay gagamitin basihan para i-assess ang problema ng bansa sa naturang usapin. Sa kasalukuyan anya, nasa siyam na ospital na mula sa Maynila ang nakibahagi sa naturang pag-aaral, kabilang ang Dr. Jose Fabella Memorial Hospital, Hospital ng Maynila Medical Center at Jose Reyes Memorial Medical Center. Base sa datos sa Health Organization of 2016, nasa 1,786 ang mga ina na nasawi dahil sa panganganak at 10% sa mga ito ay sanhi ng sepsis. Kasama mo sa lungsod na Maynila, Radyo Madakal Bayan, ng DZXL 558 Tatak RMN.
Maraming salamat Radyo Man, Raquel Bayan. At 100 mga patrol vehicle naman ibinigay po ng Japan government sa PNP. Ang kasama mo sa Balita, Rhea Mamogay. Rhea.
Kasamang Rod, 100 mga bagong patrol vehicles ang ibinigay ng Japan government sa Philippine National Police. Pinungunahan mismo ni PNP Chief Ronald De La Rosa at ni Japanese Ambassador Hoji Kaneda ang ceremonial turnover and blessing sa 100 patrol vehicle na isinagawa mismo sa harap ng PNP National Headquarters sa loob ng Camp Crame. Ayon kay PNP Chief Ronald De La Rosa, ang 100 bagong patrol vehicles na ito ay may halagang 210 million pesos na malaking maitutulong sa ginagawang pagpapatrolya ng PNP na layong mabawasan ng anumang krimen. Pero sinabi nila ng opisyal na may solusyon ang Japan government. Ito'y gusto nilang i-deploy ang mga bagong patrol vehicles sa mga lugar na maraming naninirahang mga Japanese. Pinayuhan na rin ni De La Rosa ang mga PNP Directorate for Logistics na tiyaking gagamitin lamang ang mga bagong patrol vehicles sa pagpapatrolya at hindi para gawing personal na gamit ng commander o di kay ipa-repaint ito talaga private vehicles. Kasama mo sa Campo Crame, Radyo Man, Rhea Mamogay ng DZXL 558 Tatak RMN.
Maraming salamat Radyo Man, Rhea Mamogay. At mga kasama, dumako naman tayo sa Kamara kaugnay ito sa pagdinig ng Committee on Justice sa impeachment complaint laban kay Chief Justice Lourdes Sereno. Nandiyan nakantabay si Radyo Man, Conde Batak.
Kasama Rod, muling nagpapatuloy itong pagdinig sa probable cause ng impeachment complaint laban na kay Chief Justice Maria Lourdes Sereno, kung saan ay nagtatanong ngayon si Congressman Kit Belmonte kay Supreme Court Associate Justice Teresita De Castro para sa ilang paglilinaw sa creation ng regional court administrative at yung JDO, yung Judiciary Decentralized Office sa Region 7. Pakinggan natin.
DZXL Special Coverage.
That you were opposing the creation of Arcal 7.
We're opposing the creation of RCAO 7.
Because
Yes.
the first impression that was given to me was
Yes, Your
that
Honor.
it is the RCAO that was being reopened.
Yes, Your
But when
Honor.
I look closely at the administrative order of the Chief Justice, it turned out it is another office that she was creating under that administrative order.
As the justice
Yes. Yes.
thinks so, and as the justice opines, and as I understand it, during the next resolution, the next NBank meeting, December 11, 2012, the NBank session terminated AO 175-2012. And the NBank decided, basically agreed with you that there was need for further study.
Yes, Your Honor.
Yes, Your Honor.
Nothing happened to the JDO after I have interposed my objection. The JDO did not operate anymore.
It didn't operate
Yes.
anymore. And, okay. So it never did operate, and the Supreme Court and bank itself, under December 11, 2012, decided to go for further study. Yes.
This
To refer it for further
resolution
study.
referred to the deliberation on November 27.
Yes,
and
Your Honor.
stating that based on the deliberation on that date and another date, December 11, the justices decided, or the Supreme Court decided to just conduct a study on the decentralization
Yes.
in
Yes.
Region 7.
Yes, ma'am. Thank you for that, for clarifying it for my mind. Baka lang hindi ko nakuha ng eksakto. Yes, ma'am. And what you're saying is, I just have to make it clear for me. Ang impression nyo po, sa tingin nyo po, hindi ho, nag-falsify si Chief Justice kasi iba yung linabas niyang AO sa pinag-usapan ninyo nung November na NBank resolution po.
Your Honor, just please allow me to just state the facts.
Yes, please.
I do
Yes, please.
I do not want to make any legal conclusion.
Yes, Your Honor.
So I'm here to just inform you about the facts surrounding
Yes, ma'am.
the issuance of AO 175.
I stand corrected po.
And there is really a problem with the two admin order issued ordering certain court officials and judges to attend the launch. There was reference to RCAO, but actually when these AOs stated that the RCAO head had already assumed office, there's no such RCAO head. It is the JDO head actually. So that is a misnomer. There is no
misnomer.
RCAO head that was designated as of that time, as of the issuance of these admin orders. There were two admin orders requiring the attendance at the launch. There was no RCAO head. There was only a JDO head.
Yes, Your Honor. Thank you for that. This is your perception of, this is your interpretation of what happened, and I give due respect to your interpretation.
And those who attended might have been misled that it is RCAO which is being reopened, when actually it is the JDO.
I hesitate to debate with the justice. I would just like to point out again that your memo yourself, the memo yourself issued, dated December 3, pointed out that it was the RCAO you were opposing. Yes. Yes, ma'am. One more, just one more final qualification.
Just not to be, just to clarify that issue, can you read that portion that you're saying, which you are attributing to
Yes,
Madam Justice, na sinasabi mo
Mr.
na
Chair.
she is opposed to RCAO? Can you please read that?
I did ask the Madam Justice to read it, but since the chair asked me, I will. This is the second paragraph of the first, this is the second sentence of the first paragraph. with due respect to the Chief Justice, to my recollection, the resolution does not reflect the court's deliberation and the consensus of the justices. Open parenthesis, no dissent was expressed, close parenthesis, opposing the reopening of RCAO 7 when the said administrative matter was taken up on November 27, 2012.
So anong gusto niyong sabihin? Kasi ang sinasabi mo, she was opposed to RCAO.
Yes.
But that is not what is contained, or that is not the essence of what you read. Para malinaw, let us avoid misleading questions.
Mr. Chairman.
I stand corrected, Mr. Chair.
Mr. Chairman, point of information, no? That is the danger when you take things out of context. Because that is the first paragraph. And with the indulgence of the Honorable Belmonte, the first paragraph references RCAO. But the second paragraph of the same memorandum is very clear, and I read, in fact, at the end of the deliberation, after hearing the vehement objections of the justices to her administrative order, open and close parenthesis, AO number 175-20112, designating the head for the Judiciary Decentralized Office, open and close parenthesis, JDO, in the 7th Judicial Region. If I may quote the Chief Justice, she said, and the third paragraph, I will amend my administrative order. It has been made to appear that this memorandum only opposes the RCAO when the second paragraph is very clear. It is discussing the JDO, which has been turned from RCAO to JDO, the vehement objection, and I quote that from here. So please do not take things out of context.
Thank you for that. I guess that needs some clarification, because even from where I sit, I am disturbed that it is being made to appear that the Madam Justice is opposed to the RCAO, when in truth and in fact, and to my recollection, if I recall it correctly, Madam Justice, that you were once, prior to prior to the creation, prior to the assumption of Chief Justice Sereno as Chief Justice, you were once the head of this program. Is that not correct, Madam Justice?
Honor, if I may clarify.
Please.
The confusion came about because of the, I'm sorry to use this word, the attempt of the Chief Justice to give a legal basis for what she has done. So she keeps on referring to RCAO, when actually what she intends to do is to establish another office which is not under the office of the court administrator. Now, when she issued the 2 administrative orders ordering everyone to attend the launch, she made reference to RCAO, and the JDO head she referred to as RCAO head, when actually there was no RCAO head, there was only JDO head. And the administrative order of the chief, 175, never made any reference to RCAO. So there was a confusion. So maybe the people, the officials and the judges who attended the launch thought it was RCAO, because she kept on saying RCAO in the order to attend. But in the AO, she's not referring to RCAO at all. So even me, at the start, thought that she should not, it's not just that I'm not opposed to RCAO in the sense that there should be no RCAO. I'm opposed to the fact that why is she reviving it at this time? And reviving it using another vehicle, which is the JDO. So
thank you for that clarification, Madam Justice, so that it will be clear of how we will consider this factual antecedents in relation to this creation of the RCAO. Thank you.
I will not debate with the Honorable Deputy Majority Leader or the Chairman of this committee. Suffice it to say, Mr. Chairman, that the administrative order itself says, on the second paragraph, the role, authority, and responsibility of the JDO head shall be in accordance with the NBank Resolution AM number 06 1206 SC dated 18 March 2008 as amended in 11 November 2008, which refers to the ARCAO. However, I will submit to the
Which
position of the
also was described as falsified.
Your Honor,
Tama ba? Mali
Your
ba?
Honor, can I...
I'm
Sige
sorry,
po.
Mr. Chair. I don't think it was falsified.
That is the proof that she is taking away the functions of the officials mentioned in the resolution of the court and giving these functions to the JDO head. That is the implication of that sentence in that AO. So she's not anymore amenable to designating a regional court regional court administrator, deputy, assistant court administrator. She wanted all of these functions to be performed by the JDO, and that was the reason for the reference to the resolution of the court. So she's not reviving the ARCAO. She's transferring the function to the JDO.
As the justice opines, and I would hesitate to contradict. I'm not in a position to debate with justice, Your Honor.
Thank you, Your Honor. Thank you.
Just one more question, Your Honor, please.
Just on this point, yung sinasabi mong AM number 12-11-9-SC refers to the reopening of the ARCAO in Region 7. Yun yung sinasabi mo, di ba?
Oh, yes, Your Honor.
Tapos, no, I'm addressing this to my colleague.
Okay.
And dito nga sa notice na ito, dun sa what is being said is that this was ratifying effectively the action of the Chief Justice to revive the ARCAO, which was questioned, because it is not consistent with what was agreed in the unbank deliberation.
Yes.
Kanya nga nagkaroon tayo ng problema. Kanya yung sinasabi mo, ito yung basis ng administrative order niya. But the problem is, there is something wrong with that basis that you are referring to, which is the anchor of your administrative order. Kanya mamimislead po tayo pag yun ang ginamit nating basihan when it did not reflect the true intent of the unbank during their deliberation of November, kailan ba yan? November 27. So,
Yes.
para lang malinaw po, no? And that is the reason for the chairs asking you to clarify this matter so that we will not be misled.
I will not argue with the chairman. Thank you very much for clarifying matters as you see it, Mr. Chair. Just one more question, ma'am. You, maybe a couple more if the justice would allow. You did say, ma'am, that the only person allowed to take notes during the end bank was the Chief Justice herself.
We also take down notes, but she's the one. She is the one instructing the clerk of court
As to the
the resolutions that should be issued based on the minutes or based on what we have discussed.
And would there be just for my enlightenment, would there be a presumption of regularity in the notes that she would issue? In the notes that she would
the presumption is disputable.
Yes, of course.
I am disputing it and presenting documents.
Exactly po, ma'am. I understand fully the position of the justice. She is disputing her notes, her interpretation of what transpired during the en-bank resolution. I have no further questions. Thank you very much.
Thank you. We now recognize Deputy Speaker Hernandez.
Thank you, Mr. Chairman. This is addressed to Justice De Castro. Just for clarification, ARCAO has an en-bank approval. JDO has no en-bank approval.
None, Your Honor.
None. Therefore, it is a blatant violation of the Supreme Court rules.
it is an infringement of the collegial nature of the authority vested by the Constitution on the Supreme Court.
So, an administrative order cannot supersede an en banc decision.
Your Honor.
And the creation of JDO doesn't have an imprimatur or approval because of a Supreme Court en banc decision on ARCAO.
It is not consistent with the resolution on ARCAO.
Because by listening to the questions earlier, they're trying to insinuate that since ARCAO was decided en banc, so therefore the creation of JDO has also the approval of the Supreme Court justices.
Honor.
So that's what they're making it appear. But I just find it quite irregular when they would like to insinuate that ARCAO is the same as JDO. And, you know, Supreme Court justices are highly intellectual individuals. You're quite deliberate in your decisions. You're quite detailed about it. It's totally unacceptable to say that ARCAO is the same as JDO.
It cannot be said that way.
Okay. Now, it was mentioned earlier there was launching of JDO.
But the notice or the directive for the officials of the court and the judges to attend mentioned the reopening of the ARCAO.
So what happened after the launching of the JDO?
Nothing happened because of my communications to the court en banc, which was taken up, and the court finally decided to issue the resolution stating that on November 27 and December 11, we have agreed that the matter should be the matter of decentralization, because the subject matter of the JDO as well as the ARCAO is decentralization in Region 7. So decentralization per se is not wrong. It is something good because you will decentralize, you will devolve to the region some of the functions of the court. But the issue is how should it be done? The court in its previous two resolutions decided that it should be done through the ARCAO. And the ARCAO has a complete set of officials, and together with the provisions as to how the staffing pattern shall be filled up. And the staffing pattern was approved by the court en banc. But the JDO, there's no such officials mentioned. Only one, Geraldine Faith Ekong, the head of the Program Management Office, who will assume all the duties and responsibilities of all the officials mentioned in the ARCAO resolution. And it is the Chief Justice who will decide as to the staffing pattern of the JDO. And the JDO is not under the office of the court administrator. I think that was the reason why the chief did not want to use the term Regional Court Administration Office. But if she uses that term, assuming that she really intended to implement the resolution of the court creating the pilot ARCAO, she should have made reference to the Regional Court Administration Office. But why is it that she still had to come up with another name? And she called it Judiciary Decentralization Office. And all throughout Administrative Order number 175, there is no mention at all of the court administrator or anything about the office of the court administrator. So that's why I'm saying, while she is trying to say that I am reviving the regional decentralization office in Region 7, she's not reviving ARCAO. She's putting up another machinery, and that is the Judiciary Decentralization Office.
Okay. Do you have any idea how much was spent in the launching?
The launching went on.
How
much?
Because obviously, nasayang yung pera doon for launching.
The court administrator may be in a better position to answer that.
It took a long time. It took a long time for this to be paid, but I think it was paid.
You think ballpark figure?
Your Honor, I was not involved in any of those, so I don't have any idea. What I remember is many of the officials of the court had to fly to Cebu, and because it was done very close to the launch already, we were told to purchase our own airfares, and if accommodations are needed, to pay for our own accommodations in Cebu, and then we will just be reimbursed later. But as to the exact amount of how much was spent for the launch in Radisson Blu, I don't have any information on that, Your Honor.
So government money was spent for nothing?
I don't have any information. Most probably.
Who would have that information, court admin?
Maybe Justice Ekong would have that information. Okay. Because at that time, what I can recall is that she was the one directly involved in the launch and setting up of the JDO, Your Honor.
So what is the pleasure of the senior deputy majority leader?
As an administrative matter, Mr. Chairman, much has been made about the creation of the ARCAO, and our court administrator cannot provide us the information that we need. I now make the motion that former Project Management Office and RTC judge, and now with the Sandigan Bayan, the Honorable Madam Ekong, her full name being Geraldine Faith Ekong, be invited to appear before the committee to shed light on this matter. So move, Mr. Chair.
Second. The COMSEC is hereby directed to issue the invitation, and likewise a subpoena duces tecum be issued for the production of documents that will relate to the expenses incurred by government, if any, on the re-establishment or revival of on the establishment of the JDO, and likewise on the other expenses in relation to the launch of the ARCAO, ACA, JDO. Thank you.
Last question. Justice De Castro, when you found out that, and in your opinion, that the creation of JDO didn't go through en banc decision, you issued a memorandum. When you issued the memorandum, your intention was purely to correct a mistake.
Yes, Your Honor, because I'm very familiar with the background of ARCAO and the decentralization in...
Therefore, you just wanted to to correct a mistake that should not be repeated because it will affect the institution in the future.
Yes. The creation of the JDO with only one person in charge will wreak havoc on the management and operation of the courts in Region 7.
So therefore, you were not emotional about it?
No, Your Honor, if I may give you the information, there are 146 judges in Region 7, and there are 1,435 personnel. And the AO is ordering the transfer of all the records to the JDO in Region 7 with only Geraldine Faith Ekong manning the office.
So therefore, you are not biased?
I'm not biased.
No, because
yes.
It's obvious that what you've done is only for the good of the institution.
Yes, Your Honor, that is
And
my only reason.
You were never emotional nor biased about it, that you never anticipated that your actions will be used in an impeachment.
Yes, Your Honor. And in fact, if I wanted to put down the chief, I would have filed a complaint against her, or I could have done something more drastic than just letting the justices amend the AO and stop the JDO from being implemented. So I didn't take any action against the chief.
Yeah, I heard it earlier, you were quite compassionate about it, that you're giving her time to correct it. And, well, you know, you've done your job, and it is what is expected of a highly respected Justice of the Supreme Court. Thank you. Member of the Supreme Court. Thank you.
Thank you, Your Honor.
Thank you. We now recognize Vice Chair Doyle Achon.
Thank you, Mr. Chair. And yes, good afternoon, my dear colleagues and all the guests. And of course, thank you for the powerful presence of one of our honorable justices of the Supreme Court, together with our honorable court administrator. I was supposed to ask a question to our Madam Justice, considering ample time has been given already discussing about ARCAO and JDO. I just heard it with the last question hurled upon by Deputy Speaker Hernandez, and you said that I was in fact very kind of the Chief Justice, because if I had ill feelings, maybe it's a paraphrase of what you said, you would have filed a more drastic action or complaint. Is that right?
Yes, Your Honor, but I just went along with the other members of the court when we just decided to issue another resolution.
Opo. Ma'am, if you were to file a complaint, what complaint would that be?
You know, in the Supreme Court, we have an ethics committee. I used to be the vice working chair of that ethics committee, which was organized during the time of Chief Justice Corona. But the term of office of the chair and the members of the ethics committee is only a period of 1 year. So after the term of Chief Justice Corona, Chief Justice Sereno never organized the ethics committee.
Okay.
It's one way of, if we have any grievance against any one of us, there is the ethics committee that can take cognizance of any complaint against any member of the court.
Okay. Thank you, Madam Justice. Mr. Chair, I would like, of course, as I said, many things have already been said by our Madam Justice. I would like to give or ask this question to our complainant na nakakamiss din at hindi nagsasalita pa kanina umaga.
Hindi ka pa nagsawa?
Your Honor, for the record, this is the first time that I have met Mr. Attorney Gadon.
Ang pogi ho, di ba?
Thank you, Honorable Congressman Doyle Yachon, and I'm glad to meet you personally, ma'am. Honorable Justice Teresita De Castro. Good afternoon po.
Yeah. Well, I would like to raise this question to the complainant, Mr. Chair.
Please respond to this, Mr. Complainant.
Yes, Your Honor. Thank you, Your Honor.
Attorney Gadon, I can see you all smiles this afternoon, but then again, I would like to ask this question. You have heard a lot already. In fact, the annex of the complaint, so with particularly the letter of the Madam Justice, and to quote it is the letter dated or the memorandum given by the Madam Justice De Castro to the Chief Justice, particularly the first paragraph, with due respect to the Chief Justice, to my recollection, the resolution does not reflect the court's deliberation and the consensus of the justices. Now, in relation to this one, in effect, there is an attribution to the justices that who participated in that deliberation, statements other than those made by them. In fact, this was reflected, in fact, testified to by Madam Justice De Castro. In fact, when she asked the clerk of court, Attorney Vidal, there was, in fact, an affirmation or confirmation given to her by the Chief Justice that when Justice Castro said, this was not the consensus. But ma'am, it was said that it was ratified already during the in-bank session. Now, Attorney Gadon, reading your complaint, and for all we know, as a lawyer, you must know that the allegations of the complaint, in fact, are material. And when you said the ground that there is culpable violation of the Constitution by falsifying the Supreme Court resolution, particularly Supreme Court resolution or administrative matter number 12-11-9, in relation to the statement of the Madam Justice, how can you now justify that there was falsification sufficient to give a basis on your complaint, Attorney Gadon?
Thank you, Your Honor. The basis, Your Honor, would be Article 171 of the Revised Penal Code, which, may I read, Your Honor?
And what does it say?
Article 171 of the Revised Penal Code, falsification by public officer, employee, or notary, or ecclesiastic minister. The penalty of prison mayor and a fine not to exceed 5,000 pesos shall be imposed upon any public officer, employee, or notary taking advantage of his official position shall falsify a document by committing any of the following acts. Sa paragraph 3, attributing to persons who have participated in an act or proceeding statements other than those in fact made by them. Maliwanag po doon na sa mga testimony ni Honorable Supreme Court Associate Justice Teresita De Castro na pinalsify po ni Chief Justice Sereno yung tungkol doon sa administrative order na yon for 2 times. The first time, when she made it appear that it is an ARCAO matter, and then it was found out that it refers to the JDO. And then the second time, yun hong when she made it appear that it was ratified by NBank, which is again another falsity. So 2 times po yun. Now, magiging culpable violation of the Constitution po yan.
Attorney Gadon, para lang malinaw, so tumbukan na ito. Para lang sa kalinawan nating lahat, ibig mo ba sabihin na pagka ang isang deliberasyon at pinag-usapan at napagkasunduan, tapos may lumabas na resolusyon at hindi doon lumabas yung pinag-usapan, masasabi mo ba itong falsifikasyon?
Yes, Your Honor, sapagkat hindi hindi yun ang talagang naging consensus.
At paano ito magiging isang basihan para sa impeachment ng pinakamataas na mahistrado ng Korte Suprema, considering there is only one ground, or there are about 4 grounds, and one of which is, as you said, culpable violation of the Constitution. How do you relate falsification to the culpable violation of the Constitution?
Sang-ayon naman po doon sa Article 8 ng Saligang Batas, ang nagsasaad po ng tungkol sa Judicial Department, yung powers ng Supreme Court. Nakalagay po doon sa Section 4, Paragraph 1, that the Supreme Court shall be composed of a Chief Justice and 14 Associate Justices. It may sit and bank or in its discretion in division of 3, 5, or 7 members. And under Section 1, that judicial power shall be vested in one Supreme Court and in such lower courts as may be established by law. Now, if we will relate this to Article 8, Section 13, the conclusion of the Supreme Court in any case submitted to it for the decision en banc or in division shall be reached in consultation before the case is assigned to a member for the writing or the opinion of the court, and a certification to this effect signed by the Chief Justice shall be issued and a copy thereof attached to the record of the case and served upon the parties. Any member who took no part or dissented or abstained from a decision or a resolution must state the reason therefor. The same requirements shall be observed by all the lower collegiate court. And in relation, Your Honor...
Attorney Gadon, can you just please submit that? Ano ba yan? Internal rules ng Supreme Court or...
the Constitution, Your Honor.
Constitution. So we will just take judicial notice of that. Please submit that pertinent portion. We would like to take advantage of the presence of Justice De Castro. Anyway, you will have many time to come back because we will call you many times over if there will be questions to you.
Yes, Your Honor. In relation to Article 11, accountability of public officers, Your Honor. That's all, Your Honor.
There was already a ruling of the Chair that you have just submitted.
Yes, Your Honor.
At this juncture, Mr. Chair, I have no further questions to Attorney Gadon. Thank you.
Thank you, Congressman Vice Chair. We now go to Congressman Deputy Speaker Gwen Garcia.
Thank you, Mr. Chair. I have asked to return regarding this particular allegation, which is falsification attributed to the Chief Justice. Now, there seems to be now a confusion between the JDO and the ARCAO. So let us go back kung saan ito nagsimula lahat. Yung confusion po. Because the very first time that this JDO is mentioned is, if I am correct, Madam Justice, is Administrative Order 175-2012. Is this correct? Justice
yes, Your
De Castro.
Honor, that's the source of the JDO.
Ito yung simula sa lahat. The very first time that itong JDO or the Judiciary Decentralized Office was ever mentioned or came to the notice of the court.
Yes, Your Honor, although the Chief Justice was invoking the resolutions of the court pertaining to ARCAO.
Yes, I will come to that, Justice De Castro.
I'm sorry, Your
Just
Honor.
to establish this, itong Administrative Order 175-2012 was issued November 9, 2012, signed by Chief Justice Maria Lourdes Sereno.
Yes, Your Honor.
Now, this administrative order designates the head for the Judiciary Decentralized Office, or JDO, in the 7th Judicial Region.
Yes, Your Honor.
But as I read, the Chief Justice refers to two administrative orders issued by the Supreme Court. One dated November of 2006, and in fact, if I may read, in the very first paragraph, the Chief Justice in this administrative order states, pursuant to the unbanked resolution of the court in AM number 06-11-09 SC, dated 14 November 2006, entitled, open quote, implementing the pilot project on enhancing the autonomy, accountability, and efficiency of the judiciary and the administration of justice, establishing and operationalizing the pilot organization infrastructure, providing for general implementation arrangements and other purposes. So this, in fact, refers to a previous resolution already passed and banked way back in 2006. Is that correct,
yes,
Justice?
Your Honor. Yes, Your Honor.
And this resolution, if we were to read this in full, this particular resolution, in fact, authorizes the operationalization of the pilot decentralized project, in particular, the establishment of the pilot ARCAO in the 7th Judicial Region. That would be a more complete representation of that particular resolution. Is that correct, Madam Justice? My question is, first of all, can a Chief Justice create an office?
No, is one of my objections.
But yet the title of this administrative order refers to JDO, not ARCAO.
Yes, Your Honor, and it is permanent in nature. It's not an ad hoc body.
So a Chief Justice cannot create an office?
No, she cannot.
Neither can, as already established by the majority leader in his interpellation, neither can the judiciary. Is that right?
Yes, Your Honor, unless, as the Vice Chair of this committee mentioned earlier, there must be a valid delegation from the legislative body for an executive official or any official of the judiciary to be able to create an office.
In fact, in your December 3 memorandum, you did make mention, paragraph 2, of, and you state, the AO of the Chief Justice cannot deprive the court and bank of its constitutional duty to exercise administrative supervision over all courts and their personnel, and the office of the court administrator of its statutory duty under Presidential Decree number 828, as amended, to assist the Supreme Court in the exercise of said power of administrative supervision. In other words, it was by Presidential Decree 828.
During the time of President Marcos.
That is right. And yet, strangely enough, in this administrative order, as the Chief Justice designates the head for the Judiciary Decentralized Office, or JDO, her reference is, I'm just quoting directly from this AO, pursuant to the en banc resolution of the court in AM number 0611-09, dated November 14, 2006, implementing the pilot project on enhancing the autonomy, accountability, efficiency. I've read all of this. Is this referring to the ARCAO?
She's referring to the ARCAO because she has to find a legal basis.
But I do not read nowhere in the administrative order is reference to the ARCAO made conveniently.
Yes.
And yet, in her verified answer, denying the allegations set forth by Attorney Gadon, and may I ask my colleagues, if you would wish, you have your verified answer copy, page 25. She states, on November 14, 2006, the Supreme Court en banc approved AM number 0611-09 SC, which, among others, authorized the operationalization of the pilot decentralized project. In particular, the establishment of the pilot ARCAO in the 7th Judicial Region. There seems to be an omission in the administrative order, and yet, in the defense, in the verified answer submitted by the Chief Justice, ARCAO is now prominently referred to, which is in fact the essence of AM number 06-11-09-SC. Is that right?
Yes, precisely, Your Honor. That I mentioned that nowhere here is the Office of the Court Administrator or the ARCAO mentioned.
I just found it striking, Madam Justice, that I have just mentioned one Supreme Court en banc resolution, because in the second paragraph, this administrative order signed by C.J. Sereno further states the role, authority, and responsibility of the JDO head shall be in accordance with the unbanked resolution in AM number 06-12-06-SC dated 18 March 2008 as amended on 11 November 2008. And if I would read the verified answer of the Chief Justice, page 26, paragraph 42, on 18 March 2008, the Supreme Court issued a resolution in AM number 06-12-06-SC, which established the detailed operationalization mechanisms of the pilot RCAO-7 and defined the authority of the designated RCA and the DRCA. Now, what befuddles me, in this administrative order, I guess we have pretty well established that the Chief Justice cannot just create an office. She cannot create an office.
Yes, Your Honor.
And that this JDO, if this were to refer to another office, would be inexistent because this administrative order would be null and void because she is not vested with the authority to create a new office.
Yes, a permanent office.
Yes, to create a permanent
yes,
office.
DZXL Special Coverage. Brought to you by Surf. Subukan ng perfume na walang katulad ng Surf.
That Time Check was brought to you by Pride with Fabcon. Ituloy ang bango with Pride. Pride with Fabcon. Ituloy ang bango with Pride.
Ang bango-bango, ang bango-bango, ang bango ng detergent ko.
Sa pabanguhan ng detergent with Fabcon, ano nga bang mas gusto? Ayon sa research sa Metro Manila, halos 80% ng mga misis mas gusto ang bango ng Pride with Fabcon kaysa leading brand even after 24 hours. Dahil ang Pride may tuloy bango microbeads para sa bangong tuloy-tuloy buong araw.
Tuloy-tuloy bango.
Kaya misis, tuloy na sa Pride with Fabric Conditioner.
Tuloy-tuloy bango ng Pride with Fabcon ko.
Ituloy ang bango with Pride.